Parliamentarians have been given 3 years to rectify shortcomings in the Basic Conditions of Employment Act. This comes after the highest court in the land on Friday confirmed a ruling by the High Court in Johannesburg that the country's current labour laws for maternity leave violate the Constitution. The cited judgment was issued in October 2023. The Apex Court set aside the current 4 months maternity leave for the birth mother and 10 days paternity leave for the fathers, saying parents ought to be able to decide who among them becomes the primary caregiver.
The parents should be entitled to share the available days as they choose. In the event of disagreement, the leave contemplated in the relevant section shall be apportioned between the parents in such a way that each parent's total parental leave is as close as possible to half of 4 months and 10 days.
Justice Zugi Sashikri also found that the rights of adoptive parents and parents through surrogacy are prejudiced under the current Basic Conditions of Employment Act. She particularly stressed the rights of adoptive parents to children above the age of 2 years.
The extent of the limitation is that the parents are not afforded an opportunity to be at home, away from the workplace for the same period as other categories of parents, and that their adopted children are not afforded the opportunity to be with their adoptive parents after adoption.
As such, Shikri went on to rule that the prejudice against parents adopting children older than 2 years or against these children is also unlawful.
It is not clear what a reasonable cap should be. This is a matter best left for final determination by the legislature. As the unfair discrimination cannot be justified, an order that the capping of the age at 2 years is unconstitutional must therefore follow.
Insofar as the corresponding UIF provisions are concerned, the Apex Court found that it would be inappropriate to make a ruling as it did not have sufficient information on how the UIF benefits are calculated. Accordingly, the Minister of Labour has been ordered to provide a report to the court and the parties within the next 2.5 years. The High Court had granted lawmakers 2 years in 2023 to make amendments to the legislation. However, the Constitutional Court has given them more time.
The declarations of constitutional invalidity referred to in paragraphs 2 and 3 are suspended for a period of 36 months from the date of this order to afford Parliament an opportunity to remedy the constitutional defects giving rise to the constitutional invalidity.
Despite committing to abiding by the ruling of the Constitutional Court, the Minister of Labour is ordered to pay the costs of the application and to cancel. For Newsroom Afrika on Channel 405, I'm Juniour Khumalo at the Constitutional Court.